or
Monday. Board matter, 2019 Monday, please.
fresh matter.
So number 14 minute. And a Tuesday minute, 11th. Contempt and this, sir.
Relist on
Number 15.
15.
Number 15. 1-5. Have it on Monday or
Relist the matter on
please. Great.
I amend during the course of the day.
week's time is granted to do the needful. Denidu enhancement.
Enhancement is some. Namdu appeal ide or the cross appeal. I am for KDB, they are from the claimant.
Which project?
KDB, industrial area purpose in Raichur.
Yes.
Number 2, Sudhir Singh R. Vijapur.
Petitioner ones.
R2 to 6 are necessary, na?
He's
Relatively,
succeeding candidate's scholarship. He's not.
I scored the points more than this respondent,
Ah.
but the tribunal has passed the order without affecting the appointment of these respondent shall give the appointment on compensation bed of the.
No, correct. Now, state, we have to decide the union's application. You are the petitioner. So those, whether those respondents are, they may not be required.
They are not appeared before the tribunal. They was represented by advocate,
Ah.
but they effectively not.
Their appointments are not disturbed.
Not disturbed by
disturbed.
the tribunal is state that the appointment of the respondents are not disturbed.
You get ready at the, meanwhile, what happens, happens. You get ready on the main matter also.
Yeah,
At the
I'm
time
ready.
of hearing, if we find it's not necessary, we can decide. You don't have to wait till service and give a date. We'll hear it. At the time of hearing, if we feel that those respondents may be affected, then we can see.
Please.
So get ready. Office to put up report regarding notice issued to R2 to R6. This is the matter in the admission list on.
Macho.
Number 3, Liaquat Farid Ustad.
This matter, this matter was dismissed for non-prosecution for non-filing of paper book, my lord.
Now you have filed.
It is already filed, my lord. This
Hmm.
honorable court has directed me to file the paper book, then only my application will be considered.
Hmm.
So now notices were also issued to the parties. All parties have been served, 1 to 11 have been served. my lord.
Why so much delay
Lord, in COVID period, my lord, it was dismissed.
during the?
During COVID time, my lord.
You have filed the paper book.
Yes, my lord, it is filed.
Material.
It is filed on, my lord. Filed on 25/10.
Okay. You pay some costs.
Please,
How much?
1,000 rupees.
Huh?
1,000.
Okay. Legal service. Legal service. 2,000.
Please.
ಒಳ್ಳೆ ಬಾರ್ಗೇನಿಂಗ್ ಮಾಡ್ತಾರೆ ಕರೆಕ್ಟ್ ಅದಕ್ಕೆ 1,000 ಅಂತ one of 22 of 24 has been filed. Seeking to recall the order dated 26/2/2020, by virtue of which the appeal was dismissed for non-prosecution as paper book was not filed. Upon perusing the records, it is noticed that paper book has been filed.
Please.
Taking note of the reasons assigned in support of the application, IA 1/24 is allowed. Delay in filing the application for recalling the order of dismissal is condoned. IA 2/24 is allowed. The order dated 26/2/2020 is recalled, accepting the cause shown and in light of submission made. Full stop. In light of the lapse of the appellant, the appellant is directed to pay cost of rupees 2,000 to the advocates library
Library.
fund.
Yes, my lord.
Accordingly, appeal stands restored.
Yes.
Now,
Interim order which was operating, my lord, for final degree proceedings, my lord.
so that automatically will revive.
Yes,
You don't have to calculation. That will stand revived automatically.
my lord, if it is mentioned, because the trial court is proceeding with the matter, my lord.
Like this, the interim order in force would stand revived. Needless to state, the interim order in operation would stand revived. List the matter in final hearing in due course.
Please, much.
Bill number 4, Ganesh Kalaburagi.
So, your lordships.
Also, yes,
Bill number 5, BB Party.
My lords, appearing for appellants, my lords.
yes,
My lords, a notice has to issue to the respondents, my lords.
issue notice on IA as well as appeal to the respondents. The appellant is at liberty to serve counsel who appeared for the respondents in the writ proceedings.
Please, my lord.
Huh? AGA is directed to accept notice for respondents 42, 40 and 41.
Bill number 6, Yashas
Appearing,
Dixit.
lordships, in this matter, I am pressing for stay of execution proceedings. This is a suit for specific performance and a suit has been decreed. Now the court has ordered the decree holder, that is the plaintiff, to deposit the sale consideration amount, remaining sale consideration amount. I request your lordships to stay the further proceedings. I can argue on merits. Let them not proceed ಅಂತ ಅಷ್ಟೇ, your lordship. Execution ಹಾಕಿದ್ದಾರೆ, your lordship.
Let them deposit.
Please, your lordship.
Further thing we can.
Execution is already filed.
My lord, you will deposit the amount. That is,
Huh?
you will ready for depositing the amount, remaining amount.
Lordship, the issue is,
My lord, this is a registered agreement sale, my lord. So, for specific performance, you have filed for this.
2 lakhs, your lordship.
2 lakhs,
Balance amount.
24 lakhs. 24 lakhs. Already you have paid the 22 lakhs.
22 lakhs they have paid. But the very issue is, this agreement was made only as a loan transaction. I can substantiate,
No,
that can be.
You are not
that-
mentioned in that, this is for the loan.
My contention has been rejected by the trial court without giving due regard to the evidences, the evidence of the PW1. Your lordships. I can substantiate that, your lordships.
Appearing for the appellant and respondent on IA 2/24. The
appellant is a defendant before the trial court who suffers a degree for specific performance. The total sale consideration as per the agreement was to the tune of
24 lakhs.
Lakh 24,000,
and
24 lakhs.
24 lakhs, sorry.
And out of such consideration, a sum of which 22 lakhs had been received under the agreement.
Yes.
Now, the respondent herein has initiated the execution proceedings. The respondent is permitted to deposit the balance of sale consideration amount
Yes.
before the executing court.
Yes.
But the execution of the sale deed is stayed for till the next date of hearing.
Obliged.
In the meanwhile, the other listener,
My lordships,
the appellant to file the paper book
but dispense with me. It may kindly be it may kindly be dispensed with,
within 4 weeks.
please.
The amount which, the amount so deposited before the executing court cannot be invested in fixed deposit so as to or better interest.
Number 7, Mahesh Patil.
There is a,
Notice.
please, there is a delay, my lord. Kindly delay may be condoned. There is a delay, my lord.
Correct, that after, we'll see, we have to hear the other side. Issue notice on IA and main. Appellant is permitted to serve counsel to appear to the respondents in the writ proceeding. Yes.
There is a delay.
Hmm.
There is a delay in filing this appeal, 198 days delay. The defendant.
Let notice go. Let notice.
Entry ಮಾಡಿ.
ಆಯ್ತು ಅವ್ರು notice serve ಮಾಡ್ಬೇಕಲ್ಲ. You have come with after 198 days of delay. Issue notice. They have filed execution.
Yes, madam.
Then you serve the counsel appearing the execution proceedings also. Issue notice on IA and main. PCR to be summoned. Appellant is permitted to serve counsel appearing for the respondents in the execution proceedings as well. This would be in addition to notice report.
Number 9, Santosh Patil.
Then Respected to take notice for the respondent state.
Number 10, Shivakumar Mali Patil.
They have it on Monday, but we have not.
Relist on.
Number 11, AG.
That this petition is filed against the order of the KCT, wherein the respondent has challenged the annexure A13, the order of compulsory retirement. My lord, here the DGO on demand of 5,000 rupees for my lord issuing the NA order in respect.
Tuesday or Wednesday.
My lord,
We'll have it now. There's no
Yes.
interim order you're seeking.
illa. Instead of Tuesday, my lord, Wednesday or Thursday. Wednesday.
Relist. Now what has happened now?
No, my lord, the compulsory retirement order is set aside by the KSAT.
Just say.
Yes, my lord. On the basis that, my lord, in the cross examination and on the basis that there is no any demand and acceptance. Even then, my lord, the tainted amount was recovered from his pocket.
What has happened in the criminal case?
He has been acquitted by this honorable court.
Have a look at the latest judgment of the Supreme Apex Court.
Yes.
Live law, yesterday. We'll see, we'll have a look at it.
Number 12, Sagar Patil.
For the appellants in this case, my lord. Lord, the appellants being agreed by the order of the learned single judge wherein the circular at annexure has been set aside and a further direction has been given to the principal secretary, irrigation department to conduct an inquiry against the officials of KNNL. If lordship looks at page number 23, para 15. Facts of the case are, my lord, that a tender was, a contract was entered into between the petition appellants and the respondent for work from kilometer 1 to 5, my lord, which was for a period of four months. He didn't complete the work, my lord. Only 96% of the work was completed. Remaining he didn't complete. Later on, we inspected the work, my lord. The work was not in a proper condition. We issued notices to him to get set right the work done by him, which he didn't do. Later on, my lord, in the year 2019, we issue a circular at annexure A, asking him to pay the amount of rupees 70 lakhs above, my lord, which was challenged before the learned single judge. The learned single judge set aside that circular on the ground of limitation, my lord. Question of limitation does not arise here, my lord, because final bill is not yet been drawn, measurement book has not yet been completed, and moreover, my lord, under clause 29 of the general conditions of the contract, he cannot approach the writ courts, my lord. He has to first approach the chief engineer if he has any disputes regarding the work or any repayments. If that dispute is not settled, then he can approach the civil court by way of a suit.
Where is that clause?
My lord,
All that should have been raised before the single.
we have raised, my lord. It has been raised, but the learned single judge has not properly answered regarding that issue, my lord. Though a
Which
contention
point?
is,
Which point?
my lord, clause 29H, my lord. The flag of which side?
How has the single judge dealt with the matter? Just point out.
My lord,
So far as such contention.
my lord, at para, if lordship looks at page 23, para 16.
Now, the dispute was raised by the by the petitioner
Yes, my lord.
on the ground that he has been asked to pay
Yes, my lord.
some extra amount.
Yes, my lord.
Now that demand that is made by you is on the basis of some report that the work is not up to the mark.
Yes, my lord. Not up to the mark, my
You had
lord.
kind of internal inquiry.
Not internet. We had called him, my lord, to come and
Purpose.
attend the inquire, attend the spot, but he didn't come, my lord. He has not not been on the spot, my lord. In his absence, inquiry was conducted and it
Where
was,
is that demand?
my lord, at annexure A, my lord.
Page?
Page 50, my lord. It is
Page?
50, my lord. At page 50. Lordship would get appear for the spot inspection. Page 51, third para. ಈ ಕುರಿತು ಪುನಃ ಕೇಂದ್ರ ಕಚೇರಿಯ ಇಂಬರ ಪತ್ರಗಳಲ್ಲಿ ಕಾಮಗಾರಿಯಲ್ಲಿ ನಿರ್ಧಾರಿತ ಗುಣಮಟ್ಟವಿಲ್ಲದಿರುವ ಪ್ರಯುಕ್ತ ಟೆಂಡರ್ ನಿಯಮಾವಳಿಗಳಲ್ಲಿ ಪ್ರಕಾರ ಕ್ರಮ ವಹಿಸಲು ಸೂಚಿಸಿದ್ದು ಪ್ರಯುಕ್ತ ಸದರಿ ಕಾಲುವೆ ಕಾಮಗಾರಿಯಲ್ಲಿ ನ್ಯೂನತೆಗಳನ್ನು ಗುರುತಿಸಲು ಅನುಕೂಲವಾಗುವಂತ ಕಾಲುವೆಯಲ್ಲಿ ಗಿಡ ಗಂಟಿಗಳನ್ನು ಹಾಗೂ ಹುಳುಗಳು ತೆಗೆಯಲು ಸೂಕ್ತ ಕ್ರಮಗಳನ್ನು ಕೈಗೊಂಡು ದಿನಾಂಕ 10/10/2016 ಕಾಮಗಾರಿಯನ್ನು ಜಂಟಿ
71
ತಪಾಸಣೆ.
How much you have now raised?
My lord, we have raised a sum of rupees total 77,94,137, my lord. 71,92,261.
In addition, you have asked him to pay.
We asked him to pay.
Pay in addition.
Yes, my lord.
Okay, so now, how is so he challenged this before the single judge insofar as annexure A.
Annexure A, my lord.
So what is the finding of the single judge?
My lord, lordship would get it at lord, at the reasoning starts, my lord, from para 20, page 10, para 16. Firstly, regarding clause 29.
Yes.
My lord, the contention of Shri Sanjay Kumar C. Patil by relying on subclause A of clause 29 of the tender document that any dispute would have to be decided by the chief engineer and it is for the petitioner to approach the chief engineer with this grievance on account of the forfeiture and recovery order passed will also not hold this court much longer. Firstly, for the reason that annexure A, there is a recommendation made by the chief engineer dated 25/2019 at serial number 31. And secondly, and more importantly, for the reason that the recovery is sought to be made by KNL against the petitioner by exercising their rights under tender document, by contending that the actions taken by the petitioner in the year 2006 are faulty. Even if we presume that the work carried out by the petitioner were faulty, any action to be taken by the respondent would have to be within a period of limitation fixed by the Limitation Act, within 3 years, from the date on which the cause of action arose. In the present case, the cause of action having arisen in the year 2006, the last payment having been made on the 19/10/2006, the respondent authorities have woken up in the year 2019 after 13 years to seek for recovery.
The non-counsel for the appellant would submit that the challenge before the learned single judge as regards to the demand raised by the appellant, who is the respondent in the writ proceeding, for payment of additional amount. Payment of additional amount.
For recovery, my lord, for recovery of the amount excess.
For recovery of amount paid in excess.
Yes, my lord. Which includes AMD amount.
Full. Was a matter that could not have been entertained in writ proceedings, as it involved question of, as it involved a factual and appreciation of disputed facts. Further submitted that the manner of settling the dispute is provided under 29A.
Clause 29.
29.
Clause
Under
29 of
clause
the
20
general conditions of contract.
Of the
General conditions of contract.
conditions of contract. And the respondent, if so aggrieved by any demand raised by the appellant herein, ought to have followed the procedure for settlement of dispute. Full stop. Now, what is the single judge held that
My lord,
belated?
belated limitation and an inquiry is fixed on the officials, my lord, for the lapses on the
Right,
part of.
you are bothered only of the inquiry.
Yes.
In the light of the contentions raised uh, regarding maintainability of the writ itself, there would be an order of stay of the order passed in WP in the next date. Emergent notice
To only one respondent.
to the respondent. Appellant is at liberty to serve counsel who appeared for the respondent in the writ proceeding.
Please, my lord.
No, but all the procedure, you should, now, in case there's any dispute in settling the bill, then and there you have to do it. Now, if you have already paid the money, then before paying the money in excess, you should have found out, isn't it? That inquiry regarding measurement, quality.
My lord, till date, he has not yet come for settling the final bill itself, my lord, and he has till date, the final bill is not closed at all. He has left the work in part, my lord. He himself admits I have not completed the work. Please. My lord. My lord, in 2013, finally he was called, my lord. Again in 17, he was called. Finally, in 19, we issued the circular, my lord. My lord, whatever is there, he could have raised this dispute. My lord, till contract ends, my lord, only when the final bill is drawn. Till date, the final bill is not drawn.
Circulars are not,
Yes,
do
my
not
lord,
have
that's true.
any effect on the limitation.
But the contract comes to an end only once the final bill is drawn. He has not come for settling the final bill is drawn.
To claim from him, your limitation ends at the end of the 3 years of the transaction, earlier transaction.
My lord,
For him to claim, yes, let us say, final bill is not settled. Let us say final bill, either you have to pay something or he has to pay something, let us assume. If you have not claimed within 3 years from the last transaction, whatever it is, then your limitation is over.
my lord, even otherwise,
Your right to sue accrues.
even
Your right to sue accrues when you realize that so much of the amount is there.
yes,
Then
my lord, here the
how
question.
can you
Here-
say that final bill is the limitation?
My lord, as per tender conditions, my lord, once only the final bill is drawn.
General conditions are there.
Yes.
Can the general conditions overcome the statutory requirement of limitation act?
my lord. But the honorable, this honorable division bench of this honorable court has said when there is in the agreement, there is a clause for internal settlement. They cannot approach the courts of law, my lord, till they approach the concerned authorities for internal settlements.
No, that of course is a procedural.
Procedural,
Procedural.
based
argument.
upon that only
But
many
on
of the writ
merits,
petitions have been dismissed.
On merits,
I'll just once again,
Whatever may be your contract cannot negate a clause in a statute.
yes.
Is it not opposed to the public policy then? Then
I'll
and
once
you will
again,
say that, yes.
my
Limitation
lord,
Act does
communications,
not apply to the
communications are
final.
going on between both of us, my lord.
There are clause in the agreement of the KNNL. Many matters have come before me, so far as KNNL is concerned. There are many flaws in that. But none of the lawyers who are appearing for the KNNL are able to satisfy my queries.
Lord, this general condition of contract is applicable to all the
correct,
agreements.
you may have to now amend it or tweak it to be in accordance with the law.
Yes, my lord, that,
Otherwise it cannot prevail. That
that-
you have to apply your mind is what is being
my lord, that
indicated.
has to be done again by the principal secretary of irrigation
That's what
department.
is
That
being
I'll,
indicated.
please.
We can't
What
be
your
clear,
lordship says.
we cannot be clearer than this.
Yes, ma'am.
Please.
Number 30, Manvendra Reddy.
Relist.
18. Number 60. Mahesh Patil.
So we taken on 16th. My lord, next week.
Lord, it is with regard to promotion, my lord.
Huh?
It is with regard to promotion, my lord, where.
Let us see, requires hearing. Relist the matter on.
Number 7, KG Patil.
We will also on.
Kindly post this matter on Monday.
Relist on.
Please.
There's one pass over.
Lord, previous,
One they have to pass over.
my lord, previous matter, may I seek on 27th, my lord, kindly. Serial number 16.
Good.
May I seek on 27th?
Hmm.
27.
27.
One matter
Please.
for Monday, my lord, for order.
What is the urgent?
It's a writ appeal. Senior counsel is engaged.
You admit ಬೇರೆ submission ಹೇಳಿದ್ರೆ ಮಾಡಿ.
Serial.
What is the?
This is the.
Give it.
Serial number
Monday.
4, my lord, I have filed, my lord, memo seeking, my lord, the respondent number 1 has died.
Respondent number 1.
1 has died. 2, 4 and 5 may be, my lord, treated as, my lord, the LRs of respondent number 1.
2, 4.
2, 4 and 5.
Point one.
Please, my lord, 200-114, 200-115.
Now in 2, 4.
My lord, 2, 4 and 5 are, my lord, legal representative of defendant number 1.
LRs of.
Defendant number 1, respondent number 1. They may be treated as, my lord, legal representative of respondent number 1.
You mean to say that all LRs are already on the.
Already on record. They are children of, my lord, deceased Jagadevamma.
That counsel appearing for the appellant submit that in RFA 200-114 of 19 and 200-115 of 19. All the legal heirs of respondent number 1 are on record.
Already on record.
Accordingly, an endorsement be made in the cause title of the appeal.
Lord, one submission, my lord, matter may be, records may be called for, my lord. Suit for partition and separate position is filed. And, my lord, defendant number 2 contended, my lord, he is adopted son. And the counterclaim is filed. Suit filed by, my lord, plaintiff in respect of certain properties has been allowed. And counterclaim filed by defendant number 2 has been allowed in part. And 2 appeals are filed by, my lord, plaintiffs.
Serial number 9, sir. I had filed appeal, life imprisonment. IA number 1 was delay, condonation of delay for 87 days.
ಯಾವ date notice. We have given them time to file objection, you move it immediately.
Please.
After the lapse of that.
ಒಂದೇನೋ ಫೈಲ್ ಬೇಕಂದ್ರೆ ನಾವು amendment ಮಾಡ್ತಾರೆ. ಧನಂಜಯ, ಇಲ್ಲಿ ಕೊಡ್ರಿ.
10 ನಿಮಿಷ ನೋಡ್ರಿ ಮೇಡಮ್.
ಅವ್ನು ಮ್ಯಾಲೆ ಜಲ್ದಿ ಬರಂಗಿಲ್ಲ. ಹಾ. 4.1, 4.2. Stated as the current. So, 27 ಟೋನ್. ಈಗ ಬರ್ತಾರ್ರಿ ಸಾಹೇಬ್ರ. ನೋಟಿಸ್ ಇದು ಅವ್ರಿಗೆ ಟೇಕ್ ನೋಟಿಸ್ ಆಗ್ಬೇಕು ಇದು ಮಾಡಿದ್ರು. ಸೋಲ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಒಬ್ಬರೇ ಅದಾರ್ರಿ. ಈ ಅಡಿಷನಲ್ SPP ಟೇಕ್ ನೋಟಿಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಫೈಲ್. ಸರ್ ಇಲ್ಲೇ ಕೊಟ್ಬಿಡಿ ಸರ್. ಕೃಪಾಸಾಗರ್ ಪಾಟೀಲ್ ಸರ್ ಬರ್ತಾರ. ಇಲ್ಲ.
Serial number? To inform the other side. That request. Made on behalf of the respondent, please the matter out. Next week. Interim order, operation is extended till the next week.
Serial number 12, my lordship.
Ah,
I'm for the petitioner.
proceedings are stayed. Proceedings are stayed.
Yes, my lordship.
Ah,
I'm for the petitioner. A week accommodation may be granted.
why do you want to seek time when
Lordship,
proceedings are stayed? Just 1 minute, 15, office note says MA is disposed of. 15. What have you challenged? Correct, challenge ಮಾಡಿದ MA order challenge ಮಾಡಿ ಮತ್ತೆ MA. Yes, yes, madam.
Serial number 12, my lordship.
Why are you seeking adjournment for 5 years? Matter stayed.
My lordship,
What has been challenged?
it is an OS, my lordship, which is pending before the trial court.
Correct. For 5 years it is stayed because of the writ petition. So what is the matter? What have you challenged? You have
Lordship,
challenged an IA or mean?
IA, my lordship.
IA on what? IA number 6.
Which is produced at annexer. IA number 4, my lordship. IA number 4, which is produced at annexer E, my lordship. Page number 40. For carrying out the amendment of the print, my lordship.
Now, how are you aggrieved by this order? They have made an amendment taking note of the subsequent developments that they have been dispossessed. So how are you aggrieved by this? Whether dispossession is after the suit is filed, before the suit is filed, we'll keep it open for you to establish. If according to you, they have dispossessed you after the filing of the suit, and accordingly, the suit for permanent injunction could not have been filed. That finding could be recorded. We could keep it open. That such finding to be recorded, whether the possession has been entered into before filing of the suit or after. You wait, we can dispose it of. Yes. Yes. Huh? MA is disposed of. Challenge ಮಾಡಿರೋದೇನು? We'll list on next week.
Serial number 24, madam. I'm for the
20?
petition. 24. I'm for the petition in this case, madam. Kindly may have it next week, madam.
What have you challenged? Order on?
Order of 7 to 11C, madam. Quashing
Against its dismissal
against my dismissal
of order 7 to 11.
11C, madam.
But why the proceedings should be stayed? Why proceedings? Now, no doubt, you have filed application saying that the plaint be rejected, isn't it? That has been rejected, that IA.
Deficit court fees, my lord,
Huh?
regarding deficit court
Correct,
fees.
but why the proceeding before the trial court must be stayed? If at all we were to allow the writ petition and allow your order 7 rule 11, then the proceedings will come to an end. On merits, let it go on. On merits, let it go on. Your application will be taken up independently here. Adin stay ಕೊಡ್ಬೇಕು. Now it stayed for more than 3 years. We will vacate the stay. We'll hear this matter.
We may have it next week, my lord.
No, no, no. Order 7 to 11 is rejected. Why you the stay? Proceedings must stay. We will decide your application. If if the writ is allowed, order 7 to 11 is allowed, plain proceedings will come to an end. But we need not stay this.
There is some personal inconvenience, my lord.
No, that's okay, but I'm saying there's no looking into the nature of relief sought for. There's no ground made out to stay the proceedings. For 3 years, matter stayed. For what purpose? Nothing. This will be decided. If you succeed in this, suit comes to an end. Learned counsel appearing for the petitioner seeks for an adjournment. Please notice that the petitioner herein, who is the defendant number 1, has called in question the order passed on IA number 3 and IA number 5, as well as IA number 7. What are those IAs? 3, 5, and 7?
Order 7 rule 11C and
Relist at request finally on next week.
grateful. Interim order pending. Next week.
Order operations extended till the next day.
Grateful.
Seal number 20, madam. And for the petitioner, proxy counsel will be taken on next week, madam.
What have we challenged?
Madam, proxy counsel, counsel on record is out of station. Madam.
What do you mean?
In serial number 20, my lord, I appear for the respondent.
20.
Yes, yes, madam.
20, just wait. What is it?
Stay. Entry order is there, madam. Mm, 20.
It's only for comparison of signature by the expert. How?
Yes, madam.
20.
Yes, madam. Serial number 20. I appear for the respondent.
They're seeking for time.
No, madam, I am not seeing the petitioners.
Petitioners are seeking for time.
But there is already a proceedings are stayed, not the matter is held up. It's an old matter.
Yes,
One date, short date, my lord. 24 is a
Tariq pe Tariq.
no, short date, one short date, my lord. He's out of station, my lord.
Relist the matter on. The trial should go on. We can't keep it stuck like this. Relist next week at request.
Specific
Interim
date
order
may
में
can leave. Specific date may can leave.
Single bench. Huh? Yes,
interim order में kind election, my lord.
interim order is extended till the next day. It's made clear that in light of suit proceedings having been stayed, on the next date, both parties to be ready and no further adjournment would be granted.
Number 1. Kulappa hearing.
Yes.
My lord, the suit property is a tenanted land. Civil court is barred. There are as many as 4 writ petitions. I'm filing a memo.
Office objections,
It is a tenanted land.
office objections,
My lord,
you have to comply.
there are 4 writ petitions.
Hmm.
If they are all called together, either maintainable or not maintainable, that will be decided and disposed of. I have filed 4 writ petitions.
These are pending.
All are pending. It is first time it has come today. And the serial number 7 is also one of them. Today's list.
But those are land reforms writ petition.
But proceedings are going on before the land tribunal.
Before that,
Civil,
in the present case.
yes, ma'am. And they have, opponents have approached civil court.
The land reform is very, very different. So what is your main, you have challenged the continuance of proceedings.
Proceedings before the civil court. It is not maintainable.
Stating that matters to be decided in the land under the
Yes.
Act.
Yes.
Civil Court jurisdiction.
And proceedings are pending before the land tribunal. It is seized off.
List present writ petition along with the WP numbers so and so next week. Office
Any date,
objection-
any date.
Date code. Office objections to be complied by the next date.
Grateful.
There, what has happened? You have challenged order 7 to 11, you filed or what?
If I can satisfy my lord, notice can go. If not satisfied, it can be dismissed.
No, correct. I'm asking before the trial court, have you raised the?
Yes, I have raised.
What has happened?
He has given one judgment ruling which is not maintainable, saying that it is maintainable. Now I have a certain rulings of Supreme Court.
Number 2, Vinayak Apte.
I am proxy counsel.
Ah.
The Vinayak Apte's relative expired. He has not come today. A week's time make.
Week's time granted for taking of necessary steps.
Number 3.
Hello, one ನಿಮಿಷ. Suit dispose ಆಗಿದೆ.
Suit dispose ಆಗಿದೆ.
ಆಗಿದೆ. Customer note.
It is for release of the amount.
Only on that point you have come.
ಅದ್ರ ಮೇಲೆ ಅಷ್ಟೇ ಬೇರೆ.
Now notice, you can serve on the counsel who appeared in the suit proceedings also. Week's time granted to take necessary steps. Insofar as notice to the unserved respondents, the petitioner is at liberty to serve counsel who appeared for the parties in the suit proceedings as well. This would be in addition to notice ordered to court. For the steps to be taken as regards deceased R2A.
Okay.
Number 3, Deepak V. Bharat.
Week's time, Lord, the sole respondent has died.
So then it abates. You
Yes.
can take steps.
Yes,
The 90 days agidya,
yes, my lord, it has been.
in light of the sole respondent having died and steps not taken within the requisite period, proceedings stand abated. Yes.
There is interim order.
Huh?
Interim, since, my lord, the civil imprisonment has been ordered.
Huh?
Civil imprisonment of 8 days has been ordered. There was an interim order in the original suit, my lord.
Now, who died?
Respondent has died. But against the petitioner, there is an order of civil imprisonment. There was an interim order, my lord, fixed. 8 days civil imprisonment order is. But original suit itself came to be dismissed on merit, my lord. But during the subsistence of the injunction order, my lord, the petitioner has gifted the property. For that purpose, the miscellaneous was filed by the respondent. That came to be allowed by granting.
It is however clarified that the order of civil imprisonment ordered, which is in challenge, would be kept in abeyance for the present. While it is made clear that necessary steps to bring the legal representatives of the deceased must be taken within a period of 3 weeks from today. Yes.
Till number 4, Sandana Baswa B. Patil. Attend. Notice asked.
Stay ಆಗಿದೆ ಅದು. Stay ಆಗಿದೆ. ಯಾರು ಅದು? Put it over. Ten ಯಾರು ಕೊಡಿ? In light of the memo filed, notice is dispensed as regards respondent 2, 3, 4, 5, and 12, and also 14 at risk of the petitioner. Week's time granted finally to take steps as regards R10. Petitioners at liberty to serve counsel who appeared for R10 in the suit proceedings as well. Interim order. Earlier granted is extended till the next date. We'll list the matter, date.
Number 5, Deepak V. Bharat.
2 days time may be granted. No. The address of the first respondent has been changed. I have to take a fresh.
Is he a necessary party?
Yes, Lord, he is a contesting.
What is the IA?
Lord, IA application for order 22 rule 5, I have filed, that has been rejected.
That is inquiry regarding LRs.
Yes, my lord. Since, my lord, during the pendency of the suit, my lord, I am the daughter of the defendant number 1. Suit has been filed by the son against the father and other respondents. Suit came to be decreed, my lord, initially. And, my lord, regular appeal was filed by the plaintiff, my lord. And during the pendency of that regular appeal, my lord, the defendant number 1 died, my lord, and he had executed a will in favor of the defendant number 8, who is a petitioner here. My lord, in if final decree proceedings were pending, in RA was remanded subsequently. I may to the regular suit, my lord. I filed an application under Order 22 Rule 5. The trial court observes that, my lord, no, the remand is for limited purpose by the respondent number 1, who is a plaintiff. He had preferred appeal. Now, at this stage, the application under 22 Rule 5 cannot be entered on that ground.
You claim under the will.
I claim as a legatee.
So then under Order 22 Rule 10, isn't it?
Yes, but there should be determination. Order
happen.
22 Rule 5 is maintainable. That can be. But the question is that, my lord, when the suit itself has been reopened, now my application for bringing as a legatee
Should have been decided.
I will take steps, my lord. Since he has changed address, my lord, I will take 2 days time.
In the suit also, some counsel will be there. You take out.
He is not accepting. That's what. I had tried, my lord. The lady had taken the hand summons also.
Notice ಅಲ್ಲಿ ಸತ್ತು ಹೋಗ್ತಾರೆ ಅಷ್ಟೇ.
Once again, I will take.
2 weeks time granted to take necessary steps. The petitioner is at liberty to take out notice by way of hand summons on counsel appearing for
Respondent.
Part 10 in the trial proceedings.
Lord, in this case, already advocate VM Ashit and Ravindra Patil are appearing for respondent number 1. Respondent number 2 is also the plaintiff, my lord. They can be directed to take notice. Respondent number 1 and 2 are the plaintiff before the trial court. For one, both are plaintiffs. For one, they have filed wakalat, my lord. For respondent number 2, they can be directed to
Part 2 is a
co-plaintiff.
co-plaintiff.
Yes, ma'am.
The learned counsel who appears for R1, who is a plaintiff before the trial court, is directed to accept notice for R2, who is the co-plaintiff. Relist. Week after next.
My lord, interim order may be extended. Interim order may be extended. Still, proceedings are not stayed, only order on IA stayed. Proceedings are continuing.
Interim order, earlier part is extended till the next.
Please, madam.
Item number 1, same matter.
List along with seal number 1.
Yes.
Office objections to be complied with in the interregnum. Office objections.
Here for petitioner.
During course of the day, I will pay the process.
Who is R5?
R5 is a third party impleading applicant Mellers. The trial court has allowed the application under order
For impleading.
for impleading Mellers. He is an
We stand
agreement
granted
holder.
finally to take steps as regards R5, the petitioners at liberty to serve counsel who appeared for the 5th respondent in the trial court.
Please. Much.
Yes,
Interim order, my lords.
interim order operation extended till the next date.
Much.
To both Tirupati.
A short point is involved, sir. 2 of the parties are reported to be dead after service. The point involved is very small, sir. The lease pendants purchasers in a partition suit are made parties. And court commissioner report is submitted in FDP by the court commissioner. The original defendant number 1, who has sold the property during pendency of the proceedings, has died, sir. Died. His legal heirs are the plaintiff and her sister only. And now these lease pendants purchasers are claiming that they want to file, they have filed objections to the court commissioner report. They want to cross-examine the court commissioner. So we objected the application saying that whatever the property that is going to be allotted in the name of deceased defendant number 1 In regard to that, they will have to either have to file separate suit, or we are ready to give that portion of the property if they are ready to accept it.
Equitable adjustment in
Yes,
the
sir.
final
We
decree.
were ready, but they are not ready because his share is very small. Deceased defendant number one share is very small. So they are not agreeing for that, sir. Therefore, they filed application to cross-examine the court commissioner. Supposing these people start interfering in my litigation, my rights, I am having 83% share, sir. Because of death of my grandmother, her will, my mother's will, and my sister having relinquished rights in my favor, my rights have increased in the property. Otherwise, we were equally holding.
Now, under the preliminary decree,
Yes, sir.
the deceased party,
Defendant number one was having 16% shares.
now that has come to an end.
Yes, sir.
That has reached
Yes,
finality.
that has reached the finality.
The deceased defendant will not get more than 1/16.
16 share, 16% share, sir.
16%.
Share. And we have retained wherever these subsequent purchasers are in possession during the court commissioner work, same portion is allotted to defendant number one.
Anyhow, they cannot have a claim beyond 16%.
Yes, sir. Now, if they object for the court commissioner report, there are around 13 properties, sir. Out of that, 8 properties have been settled. 4 properties are disputed. What the court is doing is we requested the court, as far as the settlement that have taken place in regard to the properties among the family members, where there are no purchasers and their issues are not there, you pass a final decree, partial decree on those properties. Those remain disputed between the subsequent purchasers during the pendency of this suit. Their rights will decide on the merits. The court is not inclined to do that, but rather it has allowed the cross-examination of court commissioner. Now, supposing if the court commissioner report is to be set aside again, it will take too much time for me. Already I have spent 60 years, sir, not getting a decree to be enjoyed. And as per the settled law, sir, the purchasers do not have any right. They have to wait. Whatever the share that is going to be given to the
number is there. I'll pass over, we'll telephonically inform the other side.
Please.
Now, so what you are seeking now?
No, my request to the honorable court is that, sir, what the trial court is doing is, the file has grown up a bit big, sir. There is nothing in the file actually, to speak the truth. The point is my share is being allotted. What we are required to now see is the decree and the purchaser's interest involved in that. The court has said that they step in the shoes of defendant number one. That is not the law, sir. The subsequent purchasers, the purchasers during the pendency of the suit do not succeed in the steps of deceased defendant number one. What will happen is they will have to wait till the final decree is passed. Once the final decree is passed, share is allotted to the deceased defendant number one. That share they can claim. And that is what even some of the purchasers have been gone to High Court. The court said that whatever the share is going to be allotted to that defendant number one should be given to the purchasers. And few of them agreed. And they have compromised also, sir, before the mediation. Now the court is holding these settled matters also, sir. Out of the 13 properties, 8 properties are settled. Court is not taking steps. I said partial final decree can be passed because I want to reduce the litigation. Because my 13 properties would be stuck otherwise without my name being entered in the record of rights. And 60 years I have already spent, sir. My client is now 68-year-old. At the age of 3, he filed the litigation. Till today, he is not able to enjoy the property except 3 properties he is enjoying out of the 13. Now, 8 properties are getting settled. At least those properties are relieved, and those who want to contest with me, let them come. So I have given offer to them that whatever is allotted to deceased defendant number one, they can take it. They are not agreeing to that.
What have they challenged now?
The order of the trial court permitting the lease pendants purchasers to cross-examine the court commissioner.
No, correct, but now you have challenged it and now it is stuck here.
Yes, sir. Because I was rendered helpless before the trial court, because I submitted to the court, I brought all the rulings to the notice of the court saying that it cannot be so. The law states that either they have two options. They have to take the property that is going to be allotted to the defendant number one, or else they will have to wait till the final decree is passed. Then their option is open to them.
You have filed some IA before the trial court.
They had filed the IS under section 151 of CPC.
Now you have challenged the order passed on that.
Yes, that's it.
But now how?
It was a joint family property which they have purchased, sir.
So correct, now till this is disposed of, matter will remain in the same stage.
That's why I am also expediting, sir. I have made all out efforts in this matter, even after filing this, to serve the copy on their lawyer, and they took time, twice they took the time, sir. Because for them, my pending litigation is a happy source.
No, but what can we do now? He has to come, we have to hear the matter.
Yes, sir, other side has to come. Sir, even if a date is, if a date is accommodated, on that day, I will again come, sir, and pursue the matter to the court. He may be given a chance. This is what is the fact of the cases and the situation is, sir, where we stand.
1969 you are coming.
Yes, sir. The fate of my client is pathetic, sir. Except two properties, no other properties there, one house and one agricultural land. All are disputed because my father, he did it intentionally. And my father has died recently, sir, in 2021. Till then, all applications, all efforts to compromise were all distracted, sir. Never they came for any terms.
Taking note that the proceedings has emanated from suit filed in the year 1969 and regular first appeal having crystallized the rights.
Yes.
In RFA 24 of 1973.
73, sir, which came to be.
And noticing that the final decree proceedings is still to be concluded. Matter to be taken up on priority. And both sides not to seek and the respondent not to seek any adjournment on the next date. Relist the matter on date good. Next week good. Next week. 14th.
Please.
Number 10, Mahantesh Patil.
Yes.
That IA is filed, my lords, in view of the judgment, my lords, in the Asian surface sea.
Clarify.
It was rendered, my lords, full court judgment on 29/2/24.
Correct. Now what is happening?
Now the trial is, my lords, as it is pending. But IA do not survive because of the judgment, my lords. Earlier, what happened? The court is proceeded after the 6 months, my lords.
IA 1 of 2022. Learned counsel for the petitioner submits in light of order passed in so and so. Put here.
Yeah. Special leave in 13284. I will give that.
So and so. He does not press IA 1 of 2022 as a question of extension of interim order granted earlier does not arise. In light of the said submission, IA 1 of 2022 is disposed of as not calling for any further orders. What about summons?
Summons, I will take the fresh process, my lords, because now even I requested the other side, my lords, all are legal heirs who are not served. All are legal heirs of original plaintiff number 1. Some of the legal heirs they are representing, but other they are not accepting the notice.
Week's time is granted to do the needful. Week's time.
But in view of the lords, now the judgment of full court, the interim order earlier not extended because of that reason.
Further, IA 1 of 22 further requires no adjudication at the matter. In no, has it been vacated?
ಇಲ್ಲ ವೆಕೇಟ್ ಆಗಿಲ್ಲ ಅದು ಎಕ್ಸ್ಟೆನ್ಷನ್ 6 months ಆಗಿದೆ ಅಂತ ಐ ಫೈಲ್ಡ್ ಎ IA lords. Since matter is urgent continuously, that IA is also not considered.
Question of specific order for extension of the TI also interim stay also does not arise. Accordingly, IA is disposed. No adjournment. Nine.
Till number 9. Harvardkar Subodh Tirupati.
Why can't we refer it for mediation or any relief you'll get? No.
Mediation out of 13 properties, sir, 8 properties are settled, sir. 5 are not settled.
No, I'm saying no doubt we are fixing a date.
Yes,
but
sir.
if it serves your purpose of referring for me, no.
I won't think, sir, they would be
It
agreeing.
has to be a legal.
Yes.
Yes.
Till number 11. Mohammed Abdul Qayyum.
Lord, this is a writ petition by insurance company. They have deducted income tax as per Income Tax Act. They have deposited an entire award of the MSCG code, deducting 42,798, which is as per law, and our High Court has already held it is proper for the insurance company to deduct. Justice Abdul Nazir judgment is there.
No, but look at your submission in person.
It is before apex court now. Several orders are.
You appear for the claimant. Huh? Hello, what is the issue? Issue is only deduction of TDS.
TDS.
Huh.
Second page of this judgment, Supreme Court, second paragraph. The fourth issue with respect to TDS deduction or the award, it is stated that there are contradicting views on this issue by different high courts. Learned amicus curiae submitted that the decision of the High Court of Bombay has become final and it was rendered after hearing the State Road Transport Corporation. We have been informed by the learned amicus that on the issue of
No,
TDS.
it's still not settled.
Not settled.
Then?
These are SLPs pending. But as per our High Court,
Huh? After that is settled only.
that can be done, or as per our High Court judgment, order can be passed. Deduction is proper.
It's proper.
It's proper as per justice.
Putting
11. Paragraph 3 of this judgment, Your Lordship. Left sides. Having heard the learned counsel for the petitioner insurance company, I am of the view that the court below was not justified in directing the petitioner insurance company to deposit a sum of rupees 10,000 deducted by it towards TDS. Section 194A of the Income Tax Act grants exemption from payment of tax on the interest component up to rupees 50,000. Above 50,000, tax is to be deducted. This exemption has to be claimed by the respondent claimants by filing necessary return before the assessing authority. It is the statutory obligation of the petitioner insurance company to deduct the TDS from the entire interest component and deposit the same before the competent authority, which has been done in this case. A certificate to that effect.
TDS deducted, then you'll have to claim refund.
They can claim refund if there is not taxable income.
Yes.
But he is not appearing in this case. He thought it is 9th case. This is 11th case.
Yes. So in this, all the claimants have been served.
5 are the members of one family. 3 are served. 2 have filed a dispensation because issue is legal issue.
Yes, come. In front of you, You act as an amicus in this matter. Like only on the question of TDS.
TDS.
Huh? It is noticed that many of the claimants who are arrayed as respondents have been served, and notice is dispensed as regards other claimants. Only point for consideration in the present matter, as pointed out by counsel for the insurer petitioner. What have you challenged?
The EP order, running page 25, Your Lordship. Running page 25 of this writ petition, annexure A. Page 25, running page 25.
Order dated?
Order dated.
29/9/2018.
Yeah.
29/9/2018.
Yeah. This judgment order dated.
You are challenging only that portion of the order in the execution.
Only
proceeding.
only the execution is for this payment only.
Correct. ಏನ್ ಬರ್ದಿದ್ದೀರಾ? Is as regards to deduction of TDS from the compensation amount payable to the claimants. Learned counsel for the insurer submits. Though matters referred to a larger bench, the legal position is that the court need not await the reference and may decide on the basis of law prevailing as on date. Full stop. Noticing that the claimants have been served, learned counsel Sanket Appaji is appointed as an amicus to assist the court of petitioner to make available copy of writ petition with annexures to the amicus. Always to show the name of the amicus in the cause list so that he is notified of the next dates. You examine 2 points. 1, what is the position? 2, there is a reference to a larger bench. Do we have to wait or not? Relist the matter on date good. Yes.
But well.
Your Lordship, I have been entrusted this matter today, Your Lordship. I seek a short accommodation in this matter. The writ petition is by the defendants, Your Lordship. The respondents are the plaintiff before the trial court. They filed a suit for cancellation of the sale deed executed by father in favor of the defendants, Your Lordship.
You have challenged the order of amendment.
Please, Your Lordship, they had filed an IA for amendment of the plaint, seeking for inclusion of a prayer with regard to the possession, Your Lordship. Your Lordship, but the suit is filed in the year 2002. Subsequently, the plaint was returned, and again the plaint was filed in the appropriate court in the year 2013, Your Lordship. That was registered as OS number 20 of 2013, Your Lordship. And meanwhile, we had filed an suit for permanent injunction against them, Your Lordship, which came to be decreed. Now there is an order against them.
Is this the same as? Huh? Other side.
Your Lordship, basically they are seeking for amendment of the plaint in respect of a possession, Your Lordship. They have filed a suit for cancellation of sale deed, and now they are seeking for amendment in respect of possession. But meanwhile, Your Lordship, we had filed a suit against them for permanent injunction, which came to be decreed, restraining them from interfering into the possession, Your Lordship. That a judgment or order has not been challenged by them before the appellate court.
Let request relist the matter on date for 2013 suit.
Short date may be given, Your Lordship. I'll make my submissions.
Relist on date for. Interim order earlier grant is extended till the next day.
Grateful, Your Lordship.
For 30, amend the writing.
Yes. Plaintiff. What has happened to this IA3? IA3, what has happened? No, that is dismissed, against which they have come here and let us see if he comes. You call him. Pass over. Huh? Mahakumbh. Relist on date code. 14.
Number 14, DP Ambedkar.
Yes.
I'm for petitioner, my lord. The plaintiff is filed a suit for declaration and permanent injunction, my lord. In that, IA number 7 was filed for appointment of court commissioner, my lord. That has been rejected. Being agreed by that, the plaintiff approached to this court, my lord.
You are the
Plaintiff, my lord.
you are the plaintiff.
Yes, ma'am.
You had filed an application for appointment of commissioner.
Commissioner.
That has been rejected.
Rejected.
What did you want the commissioner to do? To,
That in,
what is the relief?
that 2040 site is there, my lord.
IS 7.
IA number 7, my lord.
What is the prayer in IS 7?
My lord, Mayor, that region stated in affidavit allow the appoint court commissioner being ADLR or his subordinate to measure the properties belonging to the plaintiff and defendants, and so also property belonging to municipality along with the suit property, and submit the report on the same manner. This is.
Correct. No, it has to be heard. Where's the other side?
Sangana Batwa B party.
Idhar, huh?
Mostly he is not available today, ma'am.
Huh?
He is not came today, ma'am.
Not today.
Hmm.
He's not present. Relist on date.
Much of it. Interim order may kindly extend.
Interim order earlier grant is extended till the next date. Now it's a 2012 suit.
Yes, my lord.
Huh.
Then next,
Number 70. RS Siddhapurkar.
Yesterday's matter, ma'am, appointment of commissioner.
Yeah.
I am the plaintiff in the trial
To
court.
appear for which?
Four.
4. You? 5. Who is the contesting respondent?
2 and 3.
2 and
3.
2 appears.
Unrepresented. Unrepresented.
Unrepresented. Proceedings have stayed or what?
Stayed. Earlier, along with the plaint itself, the dispute is in very narrow compass. Both the plots are situated adjacent to each other. There, it appears that the layouts are overlapping there. Therefore, I filed a suit for injunction. Title is not disputed, either of the plaintiff or of the defendant. Initially, I filed an application so that the matter could be settled immediately on presentation of the plaint. That was rejected on the ground that you have not led evidence. That is the only ground. At this stage, the application is not maintainable and it amounts to collection of evidence. That was the reason given. After completion of the
Where is that first
Annexure
order?
C, first order.
Annexure
C.
page.
Page number 28. The relevant portion would be at ink page number 34.
Page number, there's some difference. Paragraph.
Paragraph 10.
You read from paragraph 7.
Please. This is suit filed by the plaintiff seeking relief of perpetual
You are
injunction.
the plaintiff.
I am the plaintiff. To restrain the defendants or anybody claiming to them from interfering in the peaceful possession of the plaintiff over the suit scheduled property. It is the case of the plaintiff that the plaintiff trust is the absolute owner in possession of the suit properties, having purchased the same under 2 separate registered sale deeds bearing document number so and so, dated so and so. That the plot bearing number 68, 70, 71 were purchased by the plaintiff trust from the defendant number 1 for a valuable consideration of rupees 3,11,000, and plot number 69 was purchased by the plaintiff from one Sri Surya Kumar Maswantrao Valkeri for a valuable consideration of 72,000. That in pursuance of the above sale deed, name of the plaintiff trust has been entered in the corporation records, and the trust is paying the requisite taxes in respect of the suit property. Defendant number 2 to 5 are adjoining landowners. That when the authorized representative of the plaintiff trust along with civil engineer and architect were inspecting the suit properties, the defendant 2 to 5 came over the suit properties and caused obstruction, threatened them, stating that their land is also comes in the suit schedule properties. The defendant number 1 has encroached upon the property belonging to them. Defendant 2 and 5, without furnishing necessary papers in respect of their properties, are continuously harassing and interfering in the peaceful possession of the plaintiff over the suit property. Hence, the plaintiff constrained to file the present suit. To the contrary, D2 and 3 have contested the claim of plaintiff by filing written statement wherein they have denied the entire plaintiff governments as false. That after filing the written statement by D2 and 3, the court have framed issues and the case is posted for plaintiff evidence. At this stage, the plaintiff has filed an application seeking appointment of the Director of Land Records as Court Commissioner for conducting survey of 21/1 of village Bidapur. As per the provisions of that is quoted, provision is quoted there. A plain reading of the said, that is page number, provision makes it clear that the court may, for the purpose of proper adjudication of the matter in dispute, may appoint a court commissioner. In the present case, it is allegation of the plaintiff that the defendants are interfering into peaceful possession and enjoyment of plaintiff trust over the suit property. Hence, it is the burden on the plaintiff trust to prove the lawful possession of the suit property as on the date of filing of the suit and the alleged interference. At this stage, the plaintiff has not laid any evidence on his behalf to establish claim over the suit property. It is settled principles of law that plaintiff has to prove his case on his own strength, and the court commissioner cannot be appointed to collect evidence in support of his claim, so and so, so and so. Then paragraph 10. In the present case, plaintiff has not laid any evidence on his behalf in order to establish his claim. Hence, at this stage of the case, there is no ambiguity which requires appointment of court commissioner in order to clarify the ambiguity. Further, the plaintiff cannot seek appointment of court commissioner for collecting evidence for him. Therefore, I am of the opinion that the present application filed with the plaintiff is premature. No reasonable grounds have been made out by the plaintiff to allow. Hence, application filed by the plaintiff. Then evidence was completed. Both parties have laid evidence. Matter was set down for arguments. At this stage, again an application is filed, saying that I had already filed an application earlier initially. That was rejected on the ground that no evidence is recorded. Now that the evidence is completed, the dispute is only with regard to the boundaries of survey number 21/1 and 22. Both are adjacent to each other. If the boundaries are demarcated, we will know where the plaintiff stands and the defendant stands. Well, that application is now rejected on the ground that it amounts to collection of evidence, and I have to prove it again. Almost same order. That your lordship will get it, page number 45, paragraph 8. Mary. Paragraph 8. I have carefully gone through the records and contention of the plaintiff that there is a dispute of defendant regarding boundaries of land survey number 21/1 and where the suit plots are situated. Plaintiff filed suit for perpetual injunction restraining the defendant, contending that he is the absolute owner of the suitable property. Plaintiff has purchased the suitable property through registered sale deed from its previous owner, that is defendant number 1 and 1 Sri Suryakumar Baswantrao, for a valuable consideration. In pursuance of the registered sale deed, plaintiff became the absolute owner of the suitable property. Name of plaintiff has been entered in the relevant records. Authorized person of plaintiff examined himself of PW1, got marked documents on behalf of plaintiff as exhibit P1 to 16, sale deed got marked at P10 to P11. PW1 in his cross-examination clearly admitting that before purchasing the suitable property, they have conducted survey from an independent surveyor. As per the admission of PW1, it is clear that the plaintiff, before purchasing the suitable property, has made survey and purchased the suitable property. After survey only, plaintiff has purchased the suitable property. It is well settled principle that when the plaintiff filed a suit for perpetual injunction restraining the defendant from interference, contending that the plaintiff is absolute owner and possessor of suitable property, he has to prove that he is in possession of suitable property as on the date of the suit. But the plaintiff filed an application for appointment of commissioner where the suit plots are located. Therefore, it amounts to collection of evidence that where the suitable properties are located in survey number 21/1. This was not my application at all. I never said that please locate the suit plot. I have filed an application to fix up the boundaries of both these survey numbers. My application is very clear. The judge says that to locate the suit property. That is not at all my application. When the plaintiff himself contending that the suitable properties are situated in survey number 21/1, he is absolute owner and possessor of the suit. since the purchase of real property, I have carefully gone through the decision relied by D2 and D3, wherein the Honorable High Court of Karnataka held that once the evidence is concluded and the matter reaches the stage of argument, it may not be proper for the court to appoint a court commissioner. Otherwise, it leads to de novo trial in the suit. The court has to proceed with the case from the beginning itself. Considering all these aspects of the matter, earlier application filed by the defendant also rejected. I am of the opinion that justified in rejecting the application. This is how the court approaches the application. My submission is, my lord, it does not amount to collection of evidence because I am not going to prove the interference by way of a report of the court commission. I have to independently prove that aspect of it. Now the defendants claim that their plots are also situated in survey number 21/1. There is, I think, my lord, there is some overlapping of two layouts. Both are NA lands and both layouts are approved. So if the boundaries are fixed, no harm will be cast to the defendant. They will also be benefited if it is found that their plots are situated only in survey number 22.
It has to be sent back or it has to be allowed?
Allowed. Matter is, if trial is already over, it is posted for argument. Let the trial court take the report of the commissioner and decide the matter. No de novo trial is required now. Both parties have completed their evidence. Documents are marked.
But now you're saying that it has to be demarcated.
Demarcation ನಾನು ಕೇಳಿಲ್ಲ. Boundaries fix up ಮಾಡ್ರಿ ಅಂತ ಕೇಳಿ. My application is very clear. Application is at page number 35, annexure D.
Page
35, 35, annexure D. For the reasons stated in 420 accompanying it, most humbly prayed, the Honorable Court may kindly be pleased to appoint Assistant Director of Land Records as the Court Commissioner for conducting survey of 21/1 of village Buddapur, Taluka and District Gulbarga in the interest of justice. And the other defendants, my lord, they have no objection for appointment. Only this contesting defendant 2 and 3, they object because they know that they are claiming some portion of the property in survey number 21/1.
That is a different survey number only.
Our ಬೇರೆ survey number, ನಂದು ಬೇರೆ survey. ನಮ್ದು 21/1, ಅವ್ರದ್ದು 22. Both are adjacent.
21/1. Where the plaintiff's property.
Yes.
Defendants is
22.
$29.
Now, whatever it is, if the report comes, my lord, it will be clear whether it is in 29 or 22 or in 21. Because suit is only for injunction, no rights are being decided. If ultimately, if it is found that his plot is in survey number 29, my suit would be dismissed as far as his plot is concerned.
But then you also have to accept that report.
Yes. It is on my insistence, my lord, commissioner is being appointed. I have to accept it.
Correct. Ada ಬಂದ್ಮೇಲೆ objection ಅದಕ್ಕೆ ಇನ್ನೊಂದು fresh commissioner. ನಾವೇ order ಮಾಡ್ತೀವಿ second commissioner. So you have no objection. Your property is in a different survey number. Huh? Any judgment you have? The commissioner. Now, what is collection of evidence is difficult to say.
That is one thing. Mela. The second thing is, the report of the commissioner will not entail me to claim injunction. The report itself, by itself, cannot be looked into for the purpose of grant of injunction. Injunction is a different relief which I have to prove based on my document and my evidence, oral evidence.
Which paragraph?
Para 12.
Yes, read.
Under the provisions applicable for local inspection, what is impermissible is the delegation of adjudicating power. To cite an example, if both parties claim to be in possession of the disputed property, the local inspection by the commissioner cannot be ordered to ascertain the possession. The question of possession is to be decided by the court. However, if one party alleges encroachment by another and another party denies such allegation, the commissioner can be appointed to ascertain whether there is an encroachment or not. In such a situation, the commissioner is appointed to find out the nature of possession. The report based on local inspection will be a handy tool to decide the case relating to encroachment. In a case on hand, the petitioner, to prove his assertion of encroachment, instead of leading oral evidence of witness, has applied for local inspection. The same is not only permissible but also desirable. Justice Hegde goes to the extent and say that in almost every case you have to appoint a commissioner. If we completely read this judgment, my lord. And in fact, in the second appeal at the initial stage itself, he directed me to file an application for appointment of commissioner. Alvinu, same problem with admission stage itself, an application was filed.
The writ petition is by the plaintiff before the trial court, who has assailed the order at order passed under order 26 rule 9 on IA number 11, whereby application filed by the plaintiff for appointment of the Assistant Director of Land Records for demarcation of boundaries has been rejected. It is the facts that are made out are that the suit has been filed by the plaintiff seeking for an order of perpetual injunction restraining the defendants or persons claiming through or under them from interfering with the exclusive and peaceful possession of the plaintiff over the suit schedule property. The facts made out by the plaintiff is that the plaintiff trust is the absolute owner in possession of suit schedule properties, having purchased the same through registered sale deeds. It is the specific assertion that what has been purchased are plot number 68, 70 and 71. Next. It is further submitted that pursuant to the registered sale deeds, name of the plaintiff has been entered in the relevant records of the local authority and taxes are paid. We'll stop next. It is only contention of the plaintiff that defendants 2 to 5 who are the adjoining landowners abutting to the layout in which plaintiff has purchased certain sites has been interfering with the plaintiff's possession. Full stop. It is a specific assertion of the plaintiff that the defendant number 1 had made a layout in survey number 14 and 21/1 of Bidapur village, Kalaburagi Taluk. While the plaintiff's property is situated in survey number
21/1.
21/1. But you're saying they also have made in 14 and 21.
14 and 21 are adjacent, our side portion, but this property is opposite High Court. 14 and 21, both the D1 was the owner. Combining those two lands, he made a layout. But 69, 70, 71, they come under 21/1.
And the defendant's property come under 14. That's your case.
Plaintiff 21/1. Aurdu 22.
Correct. In para 6 of the plaint at page 16.
Please.
Just read para 6.
Defendant 2 to 5 are adjoining landowner which is abutting the layout wherein the plaintiff trust has purchased plots. In fact, the defendant number 1, Mrs. Uday Pottery Foundry Works, who is a vendor of the plaintiff trust, in respect of 3 plots, has also made a layout in survey number 14 and 21.
So within that layout, you're saying that
within that layout,
there's a problem of demarcation. In the
Adjacent is 22. They are claiming in 21/1. Therefore, let both the lands be surveyed.
better. Take the line. ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಏನು ಬರ್ಬೋದು? Now the property of the defendants is in an adjoining layout or same layout?
22 survey number. Our own layout ada, adu 20.
Different layout.
Different layout.
Different layout.
Different layout.
Next. It is in this context of dispute that the present suit has been filed. Land counsel for the plaintiff submits that at an earlier point of time, an application was filed for conducting survey of land bearing survey number 21/1. By filing IA number 2. And the said application came to be rejected while observing that the application filed was premature as the evidence was still to be let in. It was further observed that the application filed was at a premature stage. Said application, IA number 2 came to be disposed of as per order dated 22/2/2019. Subsequently, upon conclusion of evidence, when the matter was set out for arguments, plaintiff filed IA number 11 under order 26/9 for appointment of a court commissioner, naming the additional director of land records for demarcation of boundaries of land in survey number 21/1, where the plots purchased by the plaintiff are situated, and land in survey number 22, wherein the dependents 2 and 3 have made out their claim. Said application, however, came to be rejected, observing that as evidence is concluded and matter is reached at the stage of arguments, it may not be proper for the court to appoint a commissioner, as it would lead to a de novo trial of the suit.
are the photos you are showing that there is a road, my lord.
Correct, but as per the revenue, no, whether it's shown in the, whether it is shown in the village map.
Village map.
The public road, is it?
Yes.
No, it is a public road.
Correct, then you should have you made the Tahsildar as a party?
No.
Tahsildar
Because
is-
since then suit, it was, it's a respondent suit, my lord. They have to array the party as a Tahsildar. Now I am challenging the IA allowed, my lord, because the only question is that, my lord, if at all there is a village road, the plaintiff alone could not have been obstructed. It can be proved by way of filing the village map itself. The question of appointing commissioner could not arise. And the reasonings given, my lord.
No, but in case, in the village map or in the survey document, if a road is shown, then we'll ask him to give it up.
My lord, in between the lands of the, my lord, the plaintiff and defendant, there is a road, my lord. It is a public road. But he is obstructing from only using that road, my lord. He is a neighbor of my land. But I have specifically stated in the, my lord, para number
No,
2
correct.
of the, my lord, affidavit,
No,
like
now-
in page number 19.
Correct,
In the, my lord, the rainy season and also, my lord, he used to, my lord, the borewell water to the road and troubling me to, my lord, the go of my lorries and also sugarcane, my lord, crops as to transportation. Specifically stated in the,
Now the government has passed some circular stating right of way, etc. Even if it's under private land.
he is obstructing, government is not obstructing, my lord. He is the defendant, my lord, he is the neighbor of the my land, my lord, he is obstructing, not the.
Now the plea of the respondent plaintiff is that, my lord, there is existence of road, my lord. In order to ascertain road, my lord, there are sufficient evidence, my lord, to prove by way of documentary evidence itself. My lord, and if at all the road was existing, my lord, if it is obstructed by the defendants, four of the defendants, the plaintiff alone could have not been there, my lord. Other persons could have been bypassed from that road. He alone could not have been stopped by the road. My only request to this court is that, my lord, its injunction will be against the person, not attached to the property. And second thing is that, my lord, the appointment of commissioner in such a situation when existing of road or not cannot be, because already the road, village maps, Google map, everything will be available on record. Appointing the commissioner will not be feasible.
Now let us see, why can't you refer this for mediation?
My lord, already the order has been passed by the trial court, my lord, to
That
appoint
we'll
a
see, I'm
commissioner.
saying.
But the actually facts is that, my lord, I have stated in para number 2 of the, my lord, of my affidavit.
Correct, and what I'm saying is, we'll refer it for mediation, let us see if the dispute can be settled.
Mediation, my lord.
If road exists, suppose you have some village map, let him show it to his client, and if the client, then there is no other go, there ends the matter. Suit of 10 years, only for right of way. Meanwhile, you also ascertain.
Regarding my land and his land is concerned, there is no dispute, my lord.
Correct.
Only in between the, my lord, there is a road, but I am using, but he is obstructing. That is the only, my lord.
Correct, so whether the road exists,
Ah.
you place before the mediator, whatever other records, excluding revenue record, village map, etc. Let him get instructions from his client.
Yes.
If the road exists in the public record, there ends the matter. Otherwise, the matter will have to go for evidence.
Yes.
It's a 10-year-old suit. Try in mediation, let us see. Lok Adalat is there.
Yes.
We'll refer it for mediation, not Lok Adalat.
A date may be fixed, my lord. I
Mediation
will
before
call
the
them.
trial court, my lord, not here.
Huh?
The trial court, my lord, there is also a mediation center. Let the, your lordship can direct the, my lord, interim order. Before the trial court, the mediation.
It will be difficult to settle there. Here only it will be
They will agree here, my lord.
Ah.
In taluka places, they won't.
difficult.
It
You
is
try
easy.
here, if it doesn't.
Both are available, lower councils are available in the lower court, my lord, and so parties are available there, my lord.
Correct, that's why the difficulty. If they come here, little change of environment. And in case both of you advise, if there is a public road, of course, he can't have any difference. Instead of allowing it to linger, suit of 2013, you give it a try. Nothing happens, it will come back here.
Let their next week date may be fixed, my lord. If at all, again, the date, posting the date also.
Sir, looking into the nature of dispute, it would be advisable if look into the nature of dispute relating to usage of road as claimed by the plaintiff. It would be appropriate to refer the matter for mediation. Both parties to be present before the mediation center, High Court Mediation Center on
13th or 14th.
14th in green, it was said.
13th.
13.
on 13th.
Lord, I have a benefit of interim order.
Interim order earlier granted is extended till the next date. Now, which road is he using then?
Lord, there is southern side, another road is there.
Other road?
Yes.
It could be different. Photograph.
Oops.
Number 21, Syed Fayaz.
Yes, my lord, I am appearing for the petitioners in this case.
Yes. I think respondent is not in town, R2 and R3.
Yes, ma'am.
That's why they were requesting for time. We'll have it, we'll fix a date. We'll fix some other date.
My lord,
Real,
interim order may be extended.
Interim order earlier granted is extended till the next date.
Number 22, Ganesh Kalaburagi. Tirappa Sultan, correspondent.
Side is unrepresented even. Other side is not represented. Served.
No, served.
Served.
Served. There's some council.
Yes.
There's some council has filed wakalat. Local council or is
I maybe.
source?
From
We will note his absence and give one date. If he doesn't come next date, we'll go ahead.
But
No representation for the respondent when the matter is called out. Make clear if the respondent remains absent on the next date, matter would be proceeded with in his absence. Relist the matter on date. Yes.
20.
First.
Have it on next 20. Any next date? Right. Much.
Allah. Only Friday is it?
Much.
Yes.
Interim order is there, your lordship.
But in operations extended till the next date.
Much.
Two matters are there.
Who appears for the other side?
Other side has been served, but nobody has been represented. They have remained absent.
Held sufficient. Yes. In both the matters.
Both the matters.
You are the?
I am plaintiff in one of the matters and defendant in another matter. Of the two writ petitions, I am representing in two writ petitions are connected to each other here, sir. They are arising out of two different suits. I am owner of one of the property wherein these respondents are tenant. And suit was posted for judgment. But because of an order of the Honorable High Court saying that the matter should be tried simultaneously, the judgment was blocked by the defendants. The reason being, in another matter, I have taken a stay wherein one of the defendants died. The defendant is an unmarried daughter of one of the parties in the another matters. And because of death of that unmarried daughter, His mother is already on record. She was the only legal heir. They filed a memo stating that class 2 heirs are the legal heirs. And the court kept it pending, saying that it can be decided in the judgment, let the amendment take place, bringing all the legal heirs on record. That is class 2 heirs. When class 1 heir is there is no need to bring any class 2 heir. So we had consented to bring the defendant number 4, her mother, as the legal heir. We have not objected for that. But the court went to say that class 1 and class 2 heirs may be brought on record. We cannot decide it now. Legal heirs aspect on memo, the court said we cannot decide it now, but you amend the plaint by bringing all the others on record. So that was the view taken by the court was not correct, sir.
We'll continue at 2:30.
Please.
You are only on the order on the memo.
Yes, sir.
Order
It's
on
on
the-
memo.
On the memo,
Yes.
in the companion writ.
Yes. I in fact filed my objection saying that on memo, we cannot decide the bringing of legal heirs. They have to file an proper appropriate application. But court, in spite of having filed written arguments and the rulings on those aspects, sir, was not inclined to consider it. And why they are doing this? Because there is an order of simultaneous hearing of both the matters. I have filed to evict the tenant and they have filed a partition suit against me, saying that they are the owners of half portion of my property. And whereas they filed an injunction suit against me not to evict other than due process of law, admitting that I am the owner of the entire suit property. Now contradicting, they have filed. This honorable court was pleased to vacate the TI that was passed in that injunction suit for contradictory pleadings in the suit in which they have brought the legal heirs now.
ಎರಡು ಮುಕ್ಕಾಲು ಮಾಡೋದು, 2:30. 00.
This pertains to the simultaneous trial to be conducted as per the one of the orders of the Honorable High Court, sir, wherein initially.
No, so what have you challenged in this?
Yes. 203-200, no, please. Sir.
You challenged the order at annexure A.
Yes, sir.
Passed.
Dated.
What is that order?
That is 8/11/2024. The matter which was posted for judgment was withdrawn from judgment, and it was said that the matter has to be tried with OS 242, and when that judgment is going to be passed, this has to be taken up. Yes, sir.
But that you are saying is pursuant to the order of the High Court.
That was based on the order of the High Court, but the order, the Honorable High Court has said something else which has been confused by the trial court according to my view, sir. I may be wrong, but that is my view. The court has used one word in its order, otherwise simultaneously. In its order, while passing the order.
Let's have a look at that order.
Please. Please. Order of the Honorable High Court.
Yes.
Annexure.
Annexure E.
Yes.
Huh?
Yes.
Now you read that order. Let us have a.
Please.
Now that that writ was filed by you.
No, sir. That writ was filed by the defendants.
No, but say, you appeared there.
Yes, sir. I appeared.
Correct. So in WP 201004, you are the petitioner.
Yes, sir. I am for the petitioner. This matter was pertaining to an injunction that was.
Correct. MA.
Yes.
So that is only on that point.
Yes, sir.
Now,
this thing regarding the simultaneous hearing was annexure C, sir.
Annexure
C.
Page
35.
Annexure C. The 2018 order.
Yes, sir. This suit is pending from 2018 for eviction.
So read that small order, let us know.
Yes. May I shortly brief the inter se relations between the parties?
Yes.
Sir, the petitioner herein is owner of a property bearing CTS number 113734, plot number 70. 1134/70 CTS number, which measures around 1200 plus square meters, that is 12,000 square meters, which is an APMC shop cum godown situated at APMC at Bijapur.
Yes.
So initially it so happened, sir, the defendants herein filed a suit OS number 759/17 before the second additional civil judge and JMFC Bijapur, seeking injunction not to evict other than due process of law.
You are the defendant in that suit.
I am defendant in that suit. My address was wrongly shown in the said petition, and it was seen that the notice is not served on me initially.
They obtained a decree.
Yeah, no, sir. After having obtained the injunction, they saw that the notice is not served on me. Then my client gave a notice to them that since they are long-standing tenants to my client, sir, since his father, last 50 years, they are occupying the premises of my client because my client's father died. During his minority, there were nobody in family to take care of. So her mother gave that property to her servant only who was working in their shop as a tenant. They executed an agreement also then initially, and later on they didn't execute an agreement, but it went on continuing in that fashion. But after the death of father, the property was given to her youngest son, who was then 5 to 6 years of age. So they continued, sir, paying rent, and the relations went on for a long time. And initially the property was given in auction by the APMC, that is Municipal Borough Bijapur. Then it was Municipal Borough, sir, in 1960. And they were giving certain shops to the existing shop holders, license holders, by creating a new market. So old market was to be closed. So they allotted a plot to everyone. In that, we had taken an auction purchase of that. Initially, it was for 30 years lease. Lease come sale. So after 30 years, they executed sale deed in favor of my client. So my client has purchased it. And he has paid the money that was required to be paid. These relations of the plaintiff, the petitioner herein, and the respondents continued as owner and tenant. They went on paying the rent also up to 2017. In 2017, they raised a problem to my client, and there were issues between my client and the tenants. My client had requested them to vacate because you have occupied for a long time, and they were also allotted another shop in the APMCs. Their partnership firm was allotted another property by the APMC itself. And they said that we are going to shift in that premises. They went on telling that, but they lied to my client. And finally, my client was constrained to issue notice. They smelt it and they filed a suit that he may do some harm to them. So our notice was served on them. They replied to the notice admitting the contents that they are tenants. And we were constrained to file the suit because we cannot otherwise evict him. When we filed the suit, they came and said that there is a suit pending against me. Then we appeared in that suit on our own and filed our objections, written statement, everything. But TI was made absolute. We admitted the possession saying that he is our tenant, and he has admitted my status as an owner. So TI was granted. We opposed that TI saying that since we have filed the suit, they cannot continue under the equity because I have taken appropriate remedy under the law by filing a suit. I cannot take law into my hands, so I have done it. So the court was not inclined to consider that, and there was a question before the court in that matter, sir, under section 108Q of the TP Act. Once the notice is given by a owner under 106, they should evict. They should vacate the possession within 15 days as per section 108Q of the TP Act. That is the law. That is the principle of law. Even if there is no agreement, the owner gives a notice, the tenant who is required to obey the law in terms of rule of law is required to vacate. If he doesn't vacate, then the remedy is I have to file the suit. That question of law was involved in some syndicate bank case before the Supreme Court, sir. And I was relying on that, saying that injunction cannot be granted. So that...
Now, without entering into that, that suit came to be decreed.
No, sir. It is still pending.
Injunctions.
Yes. TI was granted on IA number 1.
Okay, let's ignore it for a moment. Now what happened? Did you file suit for eviction?
No, sir. I filed suit for eviction. He obtained an injunction on me.
No, that's okay. Injunction is what? Not to dispose the
Yes, yes, sir.
Now you filed.
I filed suit for eviction.
What happened to that?
In that, he filed the written statement claiming a counterclaim that he is the owner of part of the portion.
OS number?
OS number 29/2018.
Yes.
Initially, it didn't appear, sir, in spite of service of notice. My evidence was concluded. Then he appeared, filed the written statement and counterclaim. We filed an application to exclude the counterclaim. Court was pleased to exclude the counterclaim.
No, now just tell me, in that suit for eviction, what you filed, he filed some counterclaim seeking partition.
Yes, sir.
Okay, so be it. Now, the suit for injunction and partition were directed to be disposed of together.
Yes, sir, simultaneously.
29 of 2018
and OS 242/18.
759 of 17.
No, sir. they filed another suit after the counterclaim was excluded. They filed OS 242/18 and they sought for partition of the property. And their claim in that suit was, as per an agreement, they have become owners.
No, but this order you are relying on,
I will come to that point, sir. What happened in between?
no.
When
In 24044A, 204486.
I will come on that.
That is the order which says you tried two suits together.
Yes, sir.
Huh.
Yes.
And
That
that
I'm
also
coming to, they filed an
29 and 29, that's
Sir,
all.
after they filed OS 242/18, they filed an application to club the matters. So I oppose that application, sir. So court was pleased to reject that clubbing of the matters because of divergent pleadings in the matters and they could not be tried together. And court came to conclusion that it was not safe. So also the High Court came to the conclusion that the matters being divergent, they cannot be clubbed. And therefore, the court said that they may be simultaneously tried. Otherwise, they may be disposed of, subject to the intricacies of the matters, sir. And they never cooperated to simultaneously conduct both the matters, defendants, because they want to tag my this suit to that so that I never get a fruits in my litigation. So the court, which has passed the order, it may be seen, sir. It is at page 19. Of my this thing. I will just read out. Case was posted for judgment. Advocate for defendant advanced case and filed this. He has concluded arguments also, sir. After that, this takes place. Filed a memo and produced a copy of the order passed in WP number 201296-298 of 2019, dated 11/6/2019. He submitted that as per the order passed by the Honorable High Court of Karnataka in the said writ petition, the present suit has to be disposed of with another suit which is pending on this file of this court in OS 242/18. In support of his said submission, he relied on the operative portion of the said order, which is read as under. IA 9 filed by the defendants under section 151 for clubbing of the above said two cases is rejected. However, the trial court is hereby directed to try both the suits simultaneously, and the judgments also should be passed on the same day simultaneously in the both cases. The trial court has to dispose of the said suits without being influenced by any of its observations earlier made for limited purpose of disposing of the interlocutory application.
Yes.
However, it is made clear that if for any reason the court comes to the conclusion that either of the suit be dismissed or disposed of on maintainability, the said order can be passed at any intermediate stage if the court feels that any of the suit itself is not maintainable. Otherwise, both should be tried simultaneously and disposed of. So this order, after being considered, sir, the court was pleased to hold that in view of the order of the Honorable High Court, this matter cannot be tried, judgment cannot be
Correct.
passed.
No, you are saying that there was no bar to try to pass, to decide 29 of 2018, independent of 242 of 2018, that though there was a direction to try the suit simultaneously, there's no question of clubbing.
Yes, sir.
And if any of the suit has to go on any technical point, it can be disposed of.
Yes. Now, sir, as per Annexure D, is the order of the Honorable High Court. I would like to draw the attention of the court.
Now, what is the stage of both the suits now?
My suit was ripe for judgment, sir. OS 29/2018. Eviction.
And then his suit was, he had filed a counterclaim in which suit? OS number?
29/18, which came to be excluded, for which he filed OS 242/18.
The 242/18 is the other suit.
Yes, sir, others, which have been clubbed. Both are in same court. Before the same officer. What they are doing is, sir, they won't conduct 242
Why?
because it is tagged with this suit so that I will never get justice in OS 29/18. Simultaneous, since court has said that simultaneously try it, they want to take advantage of this. It would be otherwise clubbing a litigation again, sir, for no reason.
No, 1 minute. Let us leave this here. Now go to the next.
Huh.
Go to
What
the
is the
next.
issue in that case?
Next.
Yes. That is OS 242, sir.
Ah.
In this case, after we filed a writ petition before this honorable court, in another writ petition, there were various writ petition pending between the parties earlier, sir. Now all have completed before the High Court. Now presently these two writ petitions are pending, sir. All were filed by them earlier. Only these two are filed by me. These two and the injunction one. 3 are filed by me. This was order dated 31. Order passed on memo dated 31/1/24. And the order was passed on 5/2/2024. Sorry, sir, memo. Order was passed on annexure J 27/7/24. Very small point is involved, sir. I would like to draw the attention of the court to the annexure
Page.
Page initial evidence. Page annexure A, sir, I filed memo on 25/1/2024 stating that defendant number 5 is dead as per the report received in High Court matter. And then they file a memo, annexure B, page 13. May I read the sentences?
Page.
Page 13, annexure B.
Yes.
Body of the memo, sir. The defendant number 5 died on 1/9/2021, leaving behind her defendant number 3 as her mother, defendant number 4 as her sister, and plaintiff number 1B as her brother, as her only class 2 legal heirs. The defendant number 5 died bachelor, and as such, class 2 heirs of defendant number 5, that is plaintiff number 1B, defendant number 3, and defendant number 4, are already on record. This was the memo they filed, sir. And then we filed an objection saying that as per section 15(1)(c) on the class 1 heirs.
Put in. In this succession. Who's the class 1 heir?
Mothers.
Who died?
Daughter died, sir, unmarried daughter.
Defendant number 5.
Unmarried daughter.
Unmarried daughter.
Daughter of one Mallikarjun Patil. Sorry, Mallikarjun Kakhandki.
Mother is alive.
Mother is alive.
So mother is arrayed as
Defendant number 4 in the trial court, sir. And here she is respondent number.
No, 1 minute. Defendant number 4. She is defendant number 4.
4.
So
3, sir. Sorry, sir. 3 in the trial court. 3.
This is in OS 242.
Yes, sir.
So you are saying that she will be the class 1 heir.
Only class 1 heir. Mother.
Section
15 subclause 1C. Section 15 speaks about general succession in case of female Hindu.
no sons and daughters, no husband.
No husband.
So upon mother and father.
Mother and father.
Okay.
Father has already died.
Okay. Now what happened? What was your objection?
I said, sir, mother is the only heir and I have no objection. Class 2 heirs cannot be brought. That was my contention.
Take me to that.
Annexure C, sir. Page 14 and 15. I would refer to 15, sir. I will read the relevant portion.
Just read the whole memo.
Whole memos, please. The memo filed by the plaintiffs, I will go to the body, sir. The memo filed by the plaintiffs is not maintainable in view of the fact that there is a definite provision of law under which necessary application can be moved. Hence, memo is untenable in law. That the only class 1 heirs of deceased defendant number 5 can be brought on record. But whereas, as per the averments made in memo, the defendant number 3 is class 1 heir, or class 2 heir is not mentioned, but defendant number 4, sister of deceased, and plaintiff number 1 are claimed to be class 2 heirs, whom the plaintiffs intend to bring on record or intend to state that already on record is contradictory.
Yes,
Therefore, both class 1 and class 2 heirs cannot be brought on record.
Yes. Then what is the order passed?
Please. Order is passed at annexure
Now you are the defendant in that suit.
I am defendant number 1 in that suit.
Number 1.
Yes. Annexure J. Page 36. Page 30.
Page?
Page 37, sir.
Annexure?
Annexure J. Page 41 is the orders.
Yes. Read the order.
Please. The learned counsel for the defendant number 1 has pressed for passing order on memo dated 5/2/2024 filed by the plaintiffs. This honorable court has honorably considered the same memo and permitted the plaintiffs to carry out amendment in the cause title by marking death of defendant number 5 in the cause title. Thereafter, the defendant number 1 has filed memo and prayed for keeping orders passed on memo dated 21/3 in abeyance. Later, I heard both sides on memo. The learned counsel for the defendant number 1, by referring to the provisions of Order 22, Rule 5 of CPC, urged for holding inquiry with regard to legal representatives of deceased defendant number 5. He has urged that, as per Section 15(1)(c) of Hindu Succession Act, the mother of the deceased defendant number 5 is the only legal heir is entitled to come on record. On the other hand, the learned counsel for the plaintiff has drawn the attention of the court to Section 15(2)(a) of Hindu Succession Act and submitted that since the defendant number 5 died unmarried, the property devolves upon the heirs of father of defendant number 5. Hence, all the legal heirs of father of deceased.
What is this 2A?
2A speaks about if a daughter has succeeded to the property of a father. And here, the present status of the litigation, sir, if we see, OS 759, they admit I am the owner of the property. And I file for eviction. They file suit for partition in OS number 242 for 18, only in regard to this my property, claiming that they have half share. Their grandfather by name Ningan Gowda had half share in that property.
Okay, but under 15(2)(a),
may I read it?
It goes to the father.
No, sir. According to heirs of the father.
Correct.
That is what they mean to say, sir.
So what
Heirs
is
of
wrong? That appears to be the plain reading of it.
Yes, sir.
Heirs of the father.
Heirs of the father.
And not exclusively to
Mother.
Huh.
That's what their contention is. And then in that event, sir, it was required to go for evidence and then it was required to be decided by the trial court.
Why
But
is there?
if we
no,
see
correct.
the order,
Is there any dispute on the who are the heirs?
sir, it will affect us in the later part of the litigation.
No, correct. But now, the family tree you have produced anywhere?
The plaint is there, sir, on record. I
Sure.
have produced. I refer to the.
No, otherwise, there's one way of, there's one other way of looking at it. Suppose on the basis of memo, under Rule 2A, according to them, all the heirs of the father, that would include the mother also.
Yes, sir.
And other children.
Sister and a brother.
Sister and brother, isn't it?
Yes.
It could be clarified that since no inquiry is held under Order 22, Rule 5, the mere bringing on record the legal representatives will not conclusively prove the entitlement, which is a matter to be decided during trial.
No, that's what the court has concluded, sir, that
then how
it
are
can
you
be
agree?
considered in during judgment.
How are you
But
agree?
that is not the language with which section 22(5) speaks about.
No, but why are you pressing for it now? Let it be trashed in the trial. Now let's assume there's going to be an inquiry under Order 22, Rule 5. There has to be a full-fledged inquiry, isn't it? If that inquiry now is being deferred to a later stage, so be it. It will be along with the evidence, it will be decided.
No, evidence is concluded in that litigation also, sir.
Which one?
In that 242.
Of 18.
Yes.
So then there has to be evidence on this aspect.
Then again, this all issue is there, sir. Therefore, we admitted that mother is the legal heir and we have no objection to bring mother on record.
Correct, but they don't want to give up the right.
Yes, sir.
So now.
And this memo is filed by whom, sir? Memo for bringing the legal heir is filed by plaintiff number 1B, stating that by plaintiffs. And the other defendants have neither said anything because they have kept another advocate on record for defendants. The suit is filed by a partnership firm, not family members.
But where is it said that this is not conclusive?
In the orders, 27(7) Annexure D. I will refer to the.
No, are you saying this property does not belong to the father?
No, sir. That's where the issue is actually before the court. It is partnership property, it is claimed.
It's not
Partnership. They are not claiming it, it belongs to their grandfather and then they succeeded and all. They say that he was intending to purchase and it was a partnership firm. And therefore it was partnership firm which property it belonged to. And this Mallikarjun, the father of this deceased defendant, was never a partner in the partnership firm. His son 1B has been inducted.
No, so the property belonged to the firm.
according to them.
according to them.
We say firm is a tenant. And firm itself is making a wrong representation before the court. And for which the court has recorded a finding here.
They are saying, it is your contention that the property belongs to,
Myself, petitioner.
that is the
Shankar Gowda, Siddhan Gowda Patil, owner of
Plaintiff.
the property.
plaintiff.
Plaintiff.
No,
sir.
no. The defendant in 242.
That is a partnership firms. Plaintiff is partnership firm. Not the individual parties.
It belongs-
Partnership firm files suit against me,
huh.
making some other family members as a party to the litigation.
So the written statement in 242, the partnership firm has claimed ownership of the property
Yes, sir.
as belonging.
Some
to-
other family properties are still there, sir,
That's
belonging.
okay. But the defense is that the property belongs to the firm
Firm,
and not to the father.
father.
The father is which party in that suit?
He's no more, sir. One Ningan Gowda was the original father of this Gurlingappa Ningappa Kakhandki. He had three sons, Gurlingappa Ningappa Kakhandki, Mallikarjun and Siddhan Gowda.
So you are saying that in light of the written statement filed by the firm, if at all 15(2)(a) is sought to be invoked, there has to be an inquiry, because unless the finding is recorded that
Yes.
it belongs to the father,
Father or
it cannot go to the heirs of the father.
yes, that's how the issue is entangled.
That's your case. Now that they have not dealt with.
Yes.
Now
That-
you have the written statement of the partnership firm.
Myself, I haven't filed, sir.
Huh.
Yes, sir, I have.
So
Please.
but you have not stated this in so many words.
No, sir, not in that detail, because we admitted that since the defendant number 3 mother is on record, why to prolong the matter? Because simultaneously that word is always was causing a headache to us, sir. When club was not permitted, simultaneously it was said they are misusing that situation to prolong our litigations.
Now in the writ petition, you have restated that.
Sir,
In the writ petition, you have stated this position.
yes, sir.
You have stated
Yes, yes.
where
Please, sir, para. Regarding the legal heirs or regarding the simultaneous?
regarding that it belongs to the firm, so it cannot go solely to the heirs of the father. That's why you want an inquiry, isn't it?
Yes, sir, yes. Sir. That specific contention I have not taken in this writ petitions.
But that is the purpose of saying order 22 rule 5.
Yes,
Inquiry.
because that they claim it as a partnership property and his father was never a partner. His son is partner because of some change in the partnership schedules.
Now correct. Now where is the written statement of the firm? Written statement of the firm in OS 242. Because you say the firm claimed ownership of the property.
Properties. Plaint I have produced, sir. It is exhibit.
Plaint is filed by them,
Yes, sir.
but they don't.
They only plead, sir. It is a firm property.
Where do you get that?
Please, sir. Para 1, they say they speak about the partition.
Page.
Page 46. It starts from page 45, sir.
Just to take me to that clause, to that averment.
Yes. Sir. First, 46. Page 46. It is not annexed, sir, actually.
Huh?
It is, I have not made annexure.
Correct. So just.
But I have filed the plain copy, sir.
No, show me anywhere to show that the firm or that there is any RTC or corporation record showing that the property in the name of the firm.
No, sir.
No,
Property is in my name.
no, you said it was,
No, they claim it is a firm's property in their plaint. May I read the first sentence of the plaint, sir? First para of the written statement,
Yes.
plaint.
yes.
The plaintiffs have filed a suit for obtaining a decree for partition and separate possession of their half share in property as described in para 2 of the plaint by meets and bonds, and for permanent injunction restraining the defendant number 1 from dispossessing them from the property as described in para 2 of the plaint by obtaining an appropriate decree of partition and for costs of the suit. Here the plaintiff is Messrs. G.N. Kakandki, registered partnership firm by its partners. It is not a joint Hindu family partnership firm or anything else that they have admitted in the evidence.
And
They
the
say-
property stands in the name of,
Shankar Gowda Siddhan Gowda Patil, the owner, true owner of the properties,
that is you.
myself.
So it's their claim that it's partnership
It's a partnership property,
according to them.
according to them.
So if that were to be so, it cannot go under 2A, 15(2)(a) to the heirs of the father.
Yes,
That's your case.
that's my contentions.
But this has not been discussed by the court.
No, sir. Because since I was of the view, sir, if any legal error is there, why to delay the matter on that point? That was my view, sir.
No, sir,
Mother
no.
is there, why go on complicating the issue? But they didn't file IA, they didn't went for on hearing on that. Then our hands were tied, sir.
No, sir, what is the relief now you are seeking?
My relief is either my humble submission to the court would be, sir, 15(1)(c), according to which mother is already on record. If she is brought on record, I have no objection.
Correct, but that they have not considered.
That they have not considered, sir. So in that view of the matter, they failed to file an application as required under 22 Rule 25. I didn't get an opportunity to the illegality they wanted to bring before the court to solve it.
22 Rule 5.
Yes.
Correct.
Yes.
Huh.
So because of that, the error has cropped in, sir. And if this error is left tomorrow, they will make another ground and they may try to put me into trouble again. So that both the suits are never concluded. They are inter se parties from same house, staying in same residence.
So you are saying as of now, if under order 22 Rule 5 inquiry is ordered on the memo and objections.
Let them file an appropriate application, sir. That is.
No, or let the memo be treated. Whatever objection, memo filed, etc. Let there be an inquiry under order
Please.
22 Rule 5.
Please, sir. Would do so.
Reserving liberty to both parties to give documents and
Please.
that would suffice.
That would suffice. Because partnership is not either Hindu joint family partnership upon which strength they are claiming that they are the legal heirs. Unnecessary, these issues are creating an issue in the matter, sir, because they have also made a counterclaim. In this half share, they also have a share. And they delay this matter because my 29 is not disposed of.
Just only. So this will de-link and dispose it. The
Yes.
other one will.
Yes.
Now who is your contesting respondent in this matter?
That is 1-2 respondent number 1-2.
Nobody has appeared.
Partnership. No, sir. None of them have appeared this time. 1, 2, 3, sir.
Nobody appears.
Nobody appears.
Since Ella respondents. This is 23.1.
Yes, sir.
Huh?
Yes, sir.
We'll delink this. The 23.1 is delinked from the batch, from the companion writ petition, SCL number 23, and is disposed of by this order. The defendant number 1 has filed the present writ petition seeking for setting aside of the order at annexure J whereby the trial court has allowed the memo dated 5/2/24 filed by the plaintiffs to the effect that after defendant number 5 died, the other legal heirs of defendant number 5, that is plaintiff number 1B, defendant number 3, and defendant number 4, who are the class 2 heirs,
Yes.
are already on record, and same may be noted. The brief facts are that the parties are referred to by the rank before the trial court. OS 242 of 2018 was filed by Mr. G.N. Kakhandaki, which is a registered partnership firm represented by its partners, against Shankar Gowda and Siddhappa. Shankar Gowda, Siddhappa and others, claiming the relief of passing of a decree for partition and separate possession of the plaintiff's half share along with defendant 2 to 5 by carving out such share by metes and bounds. Plaintiff had also sought for passing of a decree for permanent injunction in favor of the plaintiff against defendant number 1, restraining him from dispossessing the plaintiffs from suit property described in para 2 of the plaint, except obtaining a proper decree for partition. No, para 2 of the plaint. Except through a proper decree for partition. Next. It is a case of the defendant number 1 that during the pendency of the proceedings, defendant number 5 died. defendant number 5, Sujata, daughter of Mallikarjun Kakandaki, died. And she was not married nor had any children. Upon her death, memo came to be filed by the plaintiff, which reads as hereunder. Annexure B, page 13. Insofar as such memo, the defendant number 1 had filed objections asserting that defendant number 5 being the daughter of Mallikarjun Kakandaki was survived by the mother, who was a class 1 heir.
Class 1.
I filed objections asserting that bucket cancelling, asserting that only class 1 heir of deceased defendant number 5 could be brought on record. It was also specifically averred in the set objections to the memo that there is a reference to defendant number 4, sister of the deceased, and plaintiff 1B, who claim themselves to be class 2 heirs, who are sought to be brought on record. It was specifically contended that class 1 and class 2 heirs cannot be brought on record simultaneously. Accordingly, defendant number 1 sought for rejection of the memo. Now you filed separate memo later.
Yes, sir.
But the order now is only on the plaintiff's memo.
Considering my objections also.
Correct. Objections to that memo.
Yes.
The trial court but they have not referred to the subsequent memo filed by you.
In order, it has been
Referred.
Yes.
Next. It is also to be noticed that the defendant number 1 had filed a detailed memo at annexure D.
These.
To the effect that though court had taken note of death of defendant number 5, it had not decided as to who are the legal representatives of defendant number 5. It was specifically asserted that court ought not to take note of memo and permit the plaintiffs to amend the cause title and order of 21/3/2024 be kept in abeyance. To the said memo, next to the said memo, objections were filed by the plaintiffs on 26/3/2024 to the effect that when a female died intestate, then her legal heirs are the legal heirs of her father. That is plaintiff number 1B, comma, defendant number 3 and defendant number 4, who are already on record, and accordingly seek for dismissal of the memo filed by defendant number 1. The court, after hearing both sides, has passed an order on the memo dated 27/7/2024 and allowed the memo dated 5/2/2024 filed by the plaintiff. Said order details that in terms of section 15, within bracket 2, small a of the Hindu Succession Act, where a female Hindu dies who has inherited property from her father or mother in absence of any son or daughter, same would devolve on the heirs of her father and not in terms of section 15 subclause 1. Next, it is the contention of counsel for defendant number 1 who has filed the petition that when defendant number 5 died, the mother is defendant number 3. The mother, defendant number 3, in terms of section 15(1) of the Hindu Succession Act, would be a class 1 heir, would inherit to the exclusion of the others. It is further submitted that section 15(2) small a no doubt provides that property of the female who dies intestate may devolve upon heirs of the father irrespective of order of succession under section 15(1). There must be a finding that the property that is devolved on the female belongs to the father. Next, it is further submitted that the very suit for partition is filed by the partnership firm Mrs. G.N. Kakandaki, registered partnership firm, and the plaint averments are clear that the firm claims interest in the said property, claiming half share in the property. Accordingly, it is submitted that if it is the case of the plaintiffs themselves that the partnership firm has half share in the property, then the question as to whether property can be treated as belonging to the father, and hence devolution under 15(2) small a is to flow to the legal heirs of the father is a matter to be established by an inquiry as contemplated under Order 22, Rule 5 of CPC. Next. Though memos are filed, all of which are memos are filed, and as also objections, as referred to in the narration of the facts above, it is clear that the question as to who is the legal heir of defendant number 5 is a matter that requires to be decided and cannot be decided merely on memo and objections filed. In light of the nature of contentions of defendant number 1 as stated above. Next. In light of the contentions raised by counsel for defendant number 1 as noticed above, it would be appropriate to relegate the parties to an inquiry as to the legal heir entitled to come on record in place of defendant number 5. Such determination as to who are the legal heirs of defendant number 5 is to be made in terms of Order 22, Rule 5, taking note of the contentions of defendant number 5 that the plaintiffs themselves claim half share in the property, and accordingly, if the property has to, if the legal representatives of the father are claiming right, it should be established that the property belongs to the father of D5. In light of the said discussion, order in memo is set aside. Parties are relegated to an inquiry under Order 22, Rule 5 for the court to determine as to who are the legal heirs of defendant number 5. The memos and objections filed may be the pleadings that could be relied on at the time of inquiry. Further, both sides are at liberty to file additional pleadings which would enable the court to have a full-fledged inquiry under Order 22, Rule 5. Needless to state, a detailed inquiry is being ordered, and accordingly, the entitlement of the finding as to the legal heirs of defendant number 5 would enable the court to decide devolution and division. The said inquiry is to be endeavored to be completed at the earliest. Accordingly, petition is disposed. The other one will see. It requires, there is a slight, finally it has to be decided together only.
So what has happened is,
No doubt, you have a point, but it requires some hearing on.
please, sir, please. Sir.
Now that suit may be frivolous, but finally it may have to be disposed of together.
Yes. It has to take its own course. It has to take its own course. Some directions may be given, sir, within this particular time, all the evidence, etc., is to be concluded. Because of this simultaneous order, they are playing there with me, sir. It is like clubbing the matter again.
No,
my helplessness is being.
No, correct. I agree with you. You may have to move the single judge who has disposed of the writ petition seeking for clarification. I don't know. At the most, we can dispose of the other writ petition stating that taking note of the seniority of the case, there are administrative directions of the High Court. Which year suit that is?
It is 18, sir. 2018, 7 years we have spent already.
So there are some
My,
administrative.
in my case, evidence is completed, it was posted for judgment. They never argued even in the argument, sir. After that, they came up 1 day before the judgment was to be passed, they came up with that application with a memo saying that there is a simultaneous order.
Right, so shall we dispose of that, keeping open contentions and stating, or whatever you say, keeping it, taking note of administrative directions issued by High Court for dismissal of old cases above 5 years and endeavor to dispose it of at the earliest.
That simultaneously has to be modified, word.
Then we'll have to hear it. So let it be, we'll see.
Please,
Now this though we have sent.
please,
Huh?
please.
Now there's no stay, isn't it?
There is a stay, sir. I have obtained a stay in that,
In which?
that simultaneous order,
Then
since
it-
they,
Correct, then how will the inquiry go on now?
because I have been left helpless, sir, because of that litigation, they will never conduct also, supposing.
No, correct, counsel, now. It has to go on, otherwise how will there be an inquiry?
Yes, sir.
We have to vacate the stay,
Yes, sir.
otherwise there's no point.
I do agree, sir. But some direction is required to be given because that court has tied its hands not to pass the judgment. That has to be modified.
That has to be clarified appropriately. But if the inquiry is to go on, we have to
The-
vacate the stay.
That will, the stay was obtained in 202158. By this order, it stands vacated.
20,
23.1.
so the stay was only in that.
Yes, sir. Now that gets vacated, sir, in that.
Correct. So we leave it at that.
Yes,
The
sir.
remaining case we'll see at another.
Please.
23.1 ನಲ್ಲಿ one sentence. Needless to state, in light of the direction for holding an inquiry and order 22 rule 5 expeditiously, the interim order earlier granted staying the proceedings stands vacant.
Vacate,
The other one we'll have to see.
please.
That is difficult.
If it can be posted on 14th, I'll hardly take 5 minutes.
No, there is some point. It has to be decided together only. Unless on some jurisdictional points.
Sir, then in that event, sir, let the both suits be tried on day-to-day basis. I have no objection for that.
Can't give that.
If they won't complete that litigation, what will be my fate, sir? In a simultaneous situation,
Let us see. ಅದನ್ನ ನೋಡಿ ಇನ್ನೊಂದು ಇದೆಯಲ್ಲ ಅದ್ ನೆಕ್ಸ್ಟ್ ಯಾವಾಗ
14th, can it be accommodated? Sir?
ನೋಡಿ. ಹ್ಮ್? ಹ್ಮ್.
When is the date?
Sir, ಅದು ನಮ್ದು sitting regular ಇದೆ.